What is the WARN Act for layoffs and RIFs? Imagine losing your job suddenly without warning. It can be a shock, but there are laws designed to protect workers from unexpected layoffs. One of those laws is the Worker Adjustment and Retraining Notification Act, or WARN Act. This law was passed on August 4, 1988, and took effect on February 4, 1989. Its main goal is to give employees enough time to prepare if they face a large layoff or plant closure. The idea is to help workers find new jobs or retraining options before they lose their income. It also encourages employers to be open about their plans, which helps communities stay stable during tough times. The WARN Act applies to companies with 100 or more full-time employees. It does not usually cover part-time workers, but full-time employees are protected. The law kicks in when there is a plant closing or a mass layoff. A plant closing means shutting down a single site or facility that results in losing 50 or more jobs within 30 days. A mass layoff is when at least 33% of the full-time workforce or 50 employees are laid off at one site within 30 days. When these events happen, employers must give affected workers a written notice at least 60 days before the layoff or closure. The notice must clearly state the date of the layoff, whether it is temporary or permanent, and include contact details for someone who can answer questions. Employers have to deliver this notice in a way that employees can easily receive and understand, such as by mail or hand delivery with a signature. They also need to notify local and state agencies, including the local workforce development area and the chief elected official of the local government. This way, resources can be mobilized to help workers find new jobs or training. If an employer fails to give proper notice, they can face penalties. They might have to pay back pay and benefits for each day they miss the 60-day notice period, up to 60 days. There are some exceptions to the law. Temporary project shutdowns, seasonal workers, or temporary assignments might not be covered. Also, if the number of affected employees does not meet the thresholds, the WARN Act does not apply. From the perspective of employment law, the WARN Act plays an important role during layoffs and reductions in force. Employers need to plan carefully to stay compliant. They should analyze how many employees will be affected, how long the reduction will last, and where the work is located. This helps ensure they meet all legal requirements and avoid penalties. Some states have their own laws that are stricter than the federal WARN Act, so employers must check local rules too. Not following the law can lead to costly penalties and damage to the company's reputation. Overall, the WARN Act is designed to protect workers and give them a fair chance to prepare when facing large layoffs or plant closures.